With winter arriving, the snow and the ice, I thought today would be a good time to remind you to be careful out there when it's snowy and it's icy. And I found a recent case from June that sort of is an example of why you need to be careful. We've got Hensel versus Siegfried Enterprises, and Siegfried Enterprises operates a McDonald's, and Miss Hensel during the winter, I think it was back in 2017, goes to McDonald's. It had been snowing out. It was no longer snowing, but this McDonald's had not yet plowed the parking lot, so it was slick, it was snowy, it was icy in the parking lot. Miss Hensel goes to McDonald's, gets her food, and she starts walking back out to her car, and there's a bit of a dip. She slips, falls, as you can expect. She sustained an injury. I think it was pretty severe. I think she tore her meniscus, had to have surgery. She falls. A McDonald's employee comes out to assist her. They call an ambulance, and one of the employees indicates that this happened 2 or 3 times earlier that day. So it's something that had been happening. Miss Hensel files the lawsuit against Siegfried Enterprises for her injuries, her medical expense, pain, and suffering. Siegfried Enterprises files a motion for summary judgment asking the court to dismiss the case, and the court grants that motion. She files an appeal, and so here's the basic law behind these slip and fall cases. Businesses owe their invitees a duty to keep the premises in a reasonably safe condition. But what that means in the context of snow and ice, basically the property owners have no duty to protect invitees against what are called natural accumulations of snow and ice. What does that mean in practice? Really, anything that is natural would be something that isn't man-made. So just a heavy snowfall, that's a natural accumulation, even if it hasn't been cleared. For it to be unnatural and for there to be liability, which is a defense to the no duty rule for natural accumulations, there has to be something that's man-made. Another exception to this no duty winter rule that would relieve property owner from liability is a hidden defect that the property owner knows or should know about. But of note in this case was Miss Hensel's argument that there was an unnatural accumulation of snow and ice. Unfortunately, the facts weren't really favorable to Miss Hensel. The only thing that really happened was McDonald's just didn't plow the parking lot, didn't remove the snow, didn't put down any salt or anything. But that's not grounds for liability. People are presumed to know that you need to be careful when it's snowy and it's icy out, and so that natural accumulation of snow and ice, really, Miss Hensel was out of luck. And unfortunately, the case law isn't very plaintiff friendly. We gladly take on these cases. We're happy to take on the slip and fall injury cases, knowing that they are difficult cases to prove. But I just wanted to bring this case up today just as a word of warning. Be careful out there during the winter. I'd much rather have you not fall, not injure yourself. So happy holidays.